So welcome. I'm Dory Bernstein. I'm director of the Supreme Court Institute here at Georgetown Law. Thank you all for coming. Before we get started, I would like you to all turn off anything that rings or buzzes. I want to thank our co-sponsor, the Georgetown Center for the Constitution, and Professor Randy Barnett. And I want to give special thanks to Josh Blackman over at the end, author of Unprecedented. His book, The Challenge to Obamacare, was the inspiration for this program. And so he put a lot of work into helping us plan it, and I very much appreciate that.
Dory did all the work.
Well, it's okay. You didn't have to say that. My bosses are not here. Josh will be available to sign copies during the reception immediately following the program. We have a very impressive lineup of Supreme Court practitioners who will talk about the Affordable Care Act litigation and the likely impact of the court's decision in that case, and we have a terrific moderator to lead the discussion. Adam Liptak covers the Supreme Court for the New York Times. He holds undergraduate and law degrees from Yale, and he started as a copy boy at the Times between college and law school. After a few years in private practice, Liptak returned to the Times and worked for a decade in its legal department before joining the news staff in 2002. He's taught media law to journalists and law students, and he's published articles in The New Yorker, Vanity Fair, Rolling Stone, Business Week, and The American Lawyer, as well as a few law journals. Adam will introduce our panelists, and you can take it away.
So as I understand it, and maybe I'm going to hold off for just a second in the introductions, because I think Josh was going to make a comment or two, and then maybe Randy. Was that the plan? No.
I think.
Never mind. But Josh, did you have some thoughts to kick things off with?
Sure, and let me come over to the podium. May I use the prop, Adam? May I steal it for a second?
Of course.
Thank you. Oh, you have two. This is your copy. All right. Hello, everyone. My name is Josh Blackman. I'm a law professor at the South Texas College of Law in Houston. Thank you very much for coming. I'm honored by sitting at this table. This is actually almost the entire core of attorneys who argue the case on behalf of the challengers right here. There's a couple people missing, but this is a very august panel. Plus, we have Paul Smith and Alan Morrison, two of the top Supreme Court advocates who have done so much work for the court over the years. So you're in for a treat tonight. Unfortunately, it's to suffer through me for a few minutes. And let me explain why I'm here. While the NFIB case was being argued, I was very fascinated with how quickly these arguments took off. Usually, constitutional doctrine takes a really long time to develop. So to use an example, the Second Amendment, right? We've all studied D.C. v. Heller. It took almost 25 years to go from some law review articles about guns to the Heller case. It was a very long, strewn-out process. NFIB was like that on steroids. Within a span of months, and maybe even less than a year, constitutional arguments about why a law that touches billions of dollars is not commerce flourished and developed. And the manner in which it spread was simply fascinating. Randy Barnett, who has been dubbed the godfather of the Obamacare case, and others and libertarian scholars put forth arguments about why this law is no good. If any of you had taken common law in 2009, and I would have asked you, would a law that regulates billions of dollars of the economy, would that be unconstitutional? No. The answer is, of course, it's constitutional. It regulates commerce. But enough attorneys saw a sliver of hope in that argument. They said, well, in the past, the Supreme Court had regulated certain classes of activities, growing wheat, growing marijuana. Here, they're regulating classes of inactivity, the decision not to do something. Now, you might think the argument is good or bad, but it was an argument that had legs. And with that argument, we had very strong, what were called social movements, these political groups like the Tea Party and others who rallied around this, marching 3 blocks from here in the tens of thousands, saying that this law is unconstitutional. From there, political parties got behind it, and then the lawyers took over. And we're fortunate to have people like Mike Carvin from Jones Day and Erin Murphy from the Bancroft law firm. And these attorneys presented to the courts about why these laws are unconstitutional. And it was remarkable how quickly they developed these arguments and how quickly they gained traction, how in a span of 2 years they developed a circuit split, paving the way to the Supreme Court. But this case is also about the government side, and I apologize, we don't have anyone from the government to discuss it for obvious reasons. They can't. I will do my best to relay the side of the government because I did a number of interviews with DOJ officials. But the government took this challenge serious from day one. the government realized that this case could be a legitimate Supreme Court threat, while most law professors were laughing at it. Most law professors thought this was a joke. But the government took it very seriously, and they had to develop very quickly arguments beyond, oh, that's silly. They had to say, why is this law commerce? How is the decision of how to finance a purchase of health insurance impacting interstate commerce? How is this a tax, even though the law is not framed as a tax? Or, as the Solicitor General said, if the law can be construed as a tax, why shouldn't you? These are arguments that have come up in a very short time frame, in a compressed schedule by some very, very bright individuals. And at the Supreme Court, we saw all these arguments clash in a really heroic way. The arguments developed such that the justices had a very logical way to rule either way. Now, you might agree or disagree with the outcome of the case. That's not for tonight. But what I want to focus on tonight is how the arguments were framed, how each attorney decided what to argue. And this really kind of decided the fate of the case. This wasn't, as some say, just pure politics. There were legitimate legal arguments on both sides of the case. This wasn't a case where the Republican Party hijacked the court, as some rhetoric might say. There were arguments, and these arguments have merit. And the merit comes from the constitutional vision behind it. So today we're going to have a very good discussion from the people who developed the theories, the people who argued it, and the people who witnessed this in Washington from a very close vantage point. And you will all learn a lot about a very important case that speaks volumes about our Constitution, our Supreme Court, what it means for the upcoming term with some of the big cases coming up. Thank you very much.
So I first of all want to endorse and celebrate this book. I think I first met Josh in the middle of the night when I was doing a story about people lining up to see the McDonald's Second Amendment argument. And he was maybe a law student at the time.
I think I was 1 year of law school.
He struck me as very enthusiastic, a little goofy, and not likely to amount to anything. And yet he's written really what seems to me likely to last as the definitive account of the litigation, deeply researched, completely straight, fair-minded, authoritative, accessible, clearly written. He initially sent me the galleys, naturally I looked to see what he had to say about me. But in preparation for this session, I read it, and even though as a Supreme Court reporter I'm basically forward-looking, not really interested in the stuff that's 2 terms ago, I found it to be gripping reading, and I really recommend it. Then I'm going to, before I introduce the panel, I should say that some of you may have thought that Mike Carvin's partner, Greg Katsas, was going to be able to join us. Sadly, he's home, or worse, at his in-laws, with a knee injury. But he sends word that he's delighted to have health insurance, and he wishes more people had. So let me quickly go down. It's a very accomplished panel, and we don't have that much time, so I'm going to give brief, to the point of insulting introductions. A lot of these folks are known to you anyway. Randy Barnett is well known to all of you, is the, let me give you the full title, the Carmack Waterhouse Professor of Legal Theory, and really the leading intellectual architect of the case, and is central to this whole enterprise. Erin Murphy is a lawyer with Bancroft. You may know it as Paul Clement's firm. I've learned that she's the brains behind the empty suit that is Paul Clement. Paul Smith is a leading Supreme Court and appellate practitioner across a daunting number of areas, including First Amendment law, election law, and famously argued Lawrence against Texas, the seminal gay rights case. Mike Carvin took a central role in the case under discussion of NFIB against Sebelius, and has argued every kind of case before the Supreme Court and other courts. And you may also remember him appearing before the Florida Supreme Court on behalf of George Bush in the 2000 election recount. Alan Morrison, I learned just today, well, he's the Lerner Family Associate Dean for Public Interest and Public Service at GW, has argued 20 cases in the Supreme Court, and I should have known this, but I didn't. Both the very important commercial speech case, Virginia State Board of Pharmacy, and INS against Chadha. And then, who's left? Josh, we've already talked. Okay. So, I think there's a lot of backstory in this case, but I want to try to spin it forward a little bit, get a sense of what the decision did, what its doctrinal consequences were, what its practical consequences seem to be, and whether there are other attacks left to be launched against the Affordable Care Act. And I thought maybe we'd start with Erin, who might just sketch out for us in a kind of descriptive way the 3 or 4 major holdings, if indeed they were holdings, of the decision.
Sure. And first, let me say thanks for having me, and congratulations to Josh on his fascinating book, which I commend to all of you. So what were the holdings in the case? Seems like it should be a straightforward question, but I think it's actually as complicated as anything else about the case. You could probably say there were anywhere from 3 to 5 holdings in it. The first one is probably the most straightforward, which is on the Anti-Injunction Act, and that was the question of whether the court could decide the challenge that was before it, and it's the one piece on which the court was unanimous. Everyone agreed that they could decide it because the mandate was not going to be considered a tax for purposes of the application of the Anti-Injunction Act. So then you get to the question of the mandate itself, which was really the main question in the case. And that's where I think there's some real debate about how many holdings there are. The first and primary issue that I think had really been the focus of the litigation was the Commerce Clause question, and whether this method of regulating what was regulating inactivity, or another way of putting it, compelling people to enter into commerce so that you can regulate commerce, is a valid exercise of the Commerce Clause. And we ended up with 5 justices agreeing that it is not a valid exercise of the Commerce Clause, and with the 4 dissenters writing a joint dissent and the Chief Justice writing a separate opinion that was just for himself on that piece of it. I think it's important not to overlook the other kind of component that's related to the Commerce Clause, which is the court's holding on the necessary and proper clause piece of it. And there was a separate question of, even if this isn't a means of regulating commerce, is it necessary and proper to some other aspect of regulating commerce? And that is something that had to be addressed separately, and was addressed separately by both the Chief's opinion and the joint dissent, and they both agreed that it was not. And I think there's a really important, interesting holding there, which is, particularly in the Chief Justice's opinion, where he said it doesn't matter if this is necessary legislation, it's not proper, which is something that has kind of been a debate going back and forth about whether that is a limitation or whether that's just kind of a term in the Constitution that doesn't have a whole lot of meaning. So, and then you get to the holding that actually kind of gets you the bottom line in the case, which is the Chief Justice's decision to then construe the mandate as a tax for purposes of the constitutional analysis. And in that, having construed it as a tax, he decided that it was constitutional, and was joined by a separate majority to reach a majority there. And I think that's where you get into a little bit of debate about whether the Chief Justice needed to first have the Commerce Clause decision before reaching this, or whether he could have just construed it as a tax and not addressed the Commerce Clause. He says very clearly in his opinion that he did not think he could. He considers the Commerce Clause holding a holding. So you've got 5 members of the court that consider it a holding. I think that's an interesting issue that'll be debated for some time to come. And then the last piece of the case was kind of the secondary issue that I think people were a little less focused on, which was the Medicaid expansion. And this is a challenge the states brought to the Medicaid expansion on the ground that by trying to force states to expand their Medicaid programs in a way that was very different from how they operated in the past, and telling states that if they didn't do so, they would be denied all funding for Medicaid of any kind pre-existing, the federal government was unconstitutionally coercing the states to participate in a federal program. And of the kind of variety of surprises in this case, I do think this is one people didn't really expect. 7 justices on the court agreed that the Medicaid expansion was unconstitutional, and they had a bit of a disagreement then about the consequences of that and how to deal with the severability analysis. But this was the first time in history that the court held that a spending clause piece of legislation could be unconstitutionally coercive.
So, Randy, thank you, Erin, for a very nice, crisp description of all the things that the case did. Randy and Erin were both represented challengers to the law. Randy, who won and who lost in this case?
Well, there were two. It's hard to answer that question, or people get confused in answering that question, because there were really two issues that one could win or lose on. First was our effort to defeat the Affordable Care Act and have it declared unconstitutional and save the country from the atrocious public policy that we're about to be subjected to. That was, on that issue, we didn't prevail, although we did not accomplish our objectives. Although we did, I think, weaken some of the law by successfully obtaining a limitation on what Congress can do to enforce what used to be the individual mandate is now an option to buy insurance. And we gave the states some leverage to resist the expansion of the Medicaid programs that they administer. So in that area, we basically lost. That was a loss. But in the other issue that was always involved in the case was saving the Constitution for the country. So saving the country from Affordable Care Act, that was issue number one. Then saving the Constitution for the country, because had the arguments that had been offered on behalf of the constitutionality of the Affordable Care Act prevailed, it would have meant pretty much the end of the enumerated powers scheme that the founders had put into effect in the Constitution, because at that point, whenever anything was deemed to be a national problem, then Congress would be presumed to have the power under the Necessary and Proper Clause to address the national problem, and that would basically give it the police power that the founders had denied it. And that really was the bottom line of the argument that was made by most law professors and by the government in the case. The government denied that that's what they were saying, but the bottom line is that they never found a limiting principle that would have cut short that line of analysis, that justification for future power. And that we beat. We beat it 5 votes to 4. We established 6 propositions that I went around the country for 2.5 years debating other law professors and other folks around the country, and law professors uniformly denied each one of these propositions, and there were 5 votes for each one of them. So let me just say what they are. I mean, I'm reading here now from the foreword to the book, which I did write, to give you some idea that there's something in the book that talks about this, something maybe, and elaborates on this. But I'm just going to give you the bullet points of the things that I think that we won on. These are the 6 propositions we won. We prevailed in establishing that the federal government lacks the power to compel people to engage in economic activity. We were vindicated in our claim that the government's authority to solve problems that affect the national economy is not a blank check for the expansion of federal power. We established that Congress may not simply invoke the Necessary and Proper Clause to do an end run around the limits that the Commerce Clause puts on its power. Fourth, we showed that the Congress cannot avoid the limits that the Constitution places on its powers simply by calling something a tax after the fact. Fifth, to be constitutional, any such tax must be low enough to be non-coercive and preserve the choice to conform or pay the tax. And sixth, we succeeded in showing that Congress's power to compel states to accept federal money can be coercive and also unconstitutional. In a sense, what we prevailed upon, what we actually succeeded in accomplishing, was establishing the proposition that Congress, the federal government, that Congress is one of limited and enumerated powers, that the courts can are in a position to identify what those powers are and what those limits are, and that they will enforce those limits. All propositions denied in one form or another by most of the people who thought that the bill was clearly constitutional. The second thing I just want to address briefly is, why is it that so many law professors in particular were so wrong about whether these arguments were reasonable arguments to begin with and perhaps successful arguments at the end of the day? And the reason why I think this is worth doing in front of a group of mostly law students is because I think it tells you something about where the court currently is and where it might be going in the future. One of the arguments that was made against our case, and throughout by law professors in particular, and that is that accepting our theories would essentially return us to the days before the New Deal. That the alternative to their open-ended conception, their plenary conception of federal power to address all national problems, was in fact to return to the pre-existing pre-New Deal court, which held the Congress to limited powers and did a whole bunch of other things that would have made the current welfare and regulatory state unconstitutional. I went around for 2.5 years denying that this was true. I said that the most that we'd ever accomplish as a matter of constitutional law, had we won the case, and this would have been true had we actually defeated Obamacare completely, was that this one means that Congress had never before exercised in the history of the country, which is in compelling people to engage in economic activities so they can then regulate them. This one means they've never done before, they may never do again. That's all that would be at stake. It was a theory that would be that would actually undercut one and only one statute that's ever been passed in the history of the country, the Affordable Care Act. So we couldn't have won any more than that if we'd have knocked out all of Obamacare, and we didn't win any more than that by establishing the principles that we did in the 5 votes for vote opinion that we got. So and the reason why is it that we were able to accomplish this? And the reason is because the law professors were wrong about what the alternative was. There isn't just one other alternative to the Congress may do whatever it wants to effectuate national policy. There is another alternative, and it happens to be the alternative that was adopted by the Rehnquist Court, which is an in-between position. And the in-between position can be characterized as this far and no farther. As long as you understand that it's not literally no farther, what it basically is the proposition that Congress may basically do all that it has done up till now, that we're not going to challenge the New Deal. The New Deal settlement is settled. All the powers that are currently being exercised may continue to be exercised. But if Congress wants to go farther than it went before, if it wants to go farther, then that requires a special justification. They have to explain why. They don't automatically get to go farther just because they did what they've done before. And the justification that comes, that is offered in defense of that going farther has to be something that will not lead to an unlimited police power. So A, there needs to be a justification, and B, that justification has to have limits. And that is what I believe the Rehnquist Court established. And there was good reason, or at least some reason, to question whether that philosophy... First of all, I think a lot of law professors never understood that that's really what the Rehnquist Court had done, and no more than that, but no less than that. And secondly, I think those of them who did understand that had good reason to question whether this philosophy continued to stay in existence. Because after the Raich case, which we lost 6-3, and of the 3 dissenters, we lost Justice Scalia's vote, we lost Justice Kennedy's vote, and of the 3 dissenters in that case, Justice Rehnquist is no longer on the court, and Justice O'Connor is no longer on the court, leaving us only Justice Thomas. And for all anybody knew, that's the only person, that's the only justice who still hewed to the Rehnquist Court this far and no farther view of what's called the new federalism. But what we learned in this case, is that the new federalism of the Rehnquist Court survives into the Roberts Court. There are still 5 votes for this Rehnquist Court new federalism philosophy of this far and no farther, or no farther without justification that does not lead to unlimited power. And going forward, I think that's going to be significant. Hopefully, everyone's learned their lesson now. Until there's a change of personnel, that's the jurisprudential world in which we live in. And going farther, I think, and that was a major accomplishment. That was a win. Establishing that line still exists and will be enforced by the court was a win for the Constitution.
So we're going to drill down and unpack some of those concepts, but I want to invite comments, perhaps especially from Paul or Ellen, about whether Randy's account of what happened here seems exactly right to you.
You may begin.
I guess I would say a couple things. I'm not nearly as expert at this as you are, Randy, and haven't debated this for several years, but I guess I was always of that old law professor point of view that this should have been an easy case, and I still think so, frankly. I'm still amazed that there were 5 votes that would say you can tell Wickard versus Filburn's okay. You can tell people not to grow wheat in their garden to eat it in their own kitchen, but you can't tell people who are going around relying on the promise of free care, relying on that so they don't have to buy insurance, that they ought to pay their fair share for the implicit free health care insurance that the policies of the country give them, because they know when they get cancer or a car accident, they'll get taken care of. And especially when everybody acknowledges this, including the conservative wing of the court, that the mandate was an essential linchpin of making the whole scheme work. Without it, it doesn't work. And so this is core regulation of commerce. And I think the proposition that it fundamentally would change the relationship between citizens and the federal government to allow this amount of mandate compared to the regime that existed before that bill was passed is just bizarre. I mean, it's just not, in the legal regime we live in or in the country we live in, a huge new incursion on individual liberty or some other sort of new sea change in the way that the federal government is dealing with the economy. So I frankly just You know, I continue to believe that this should not have been taken seriously, and it's really interesting to see the invocation of popular constitutionalism on the right. This is the doctrine that a lot of my left-wing professor friends always talk about, how, you know, you sort of make up the Constitution in marches and demonstrations and stuff, and now we see, well, a Tea Party was able to amend the Constitution, basically. That's the argument. Anyway, just a few random comments.
So thank you for coming and thanks for being invited here. Let me say a few words about, first, this was an unprecedented case, and there were a couple things about it that are worth noting. The first thing is, unlike almost every bill of this scope, 1,800 pages, that gets through Congress, there's a conference committee, and lots of things get straightened out in conference committee that will not end up in litigation. There was no conference committee here because Ted Kennedy died, they had a replacement, Scott Brown came in, and the Democrats lost their 60 votes needed to beat the filibuster, and so they had to go through a series of maneuvers to get it up there. So many of the things that would have been cleaned up that were put in as political matters, my own view is that sensible lawyers would have gone and cleaned up a bunch of these things, among them the Medicaid provision. There's absolutely no reason to penalize the states 100%. 5 or 10% is plenty enough, and somebody just did it because nobody thought about it. And so in that sense, I think it's a good thing that that part was struck down, the Congress needs to be more attentive to what it's actually doing in these cases. And the fact that Justices Breyer and Kagan went along with it suggests that they were unhappy with 100%, although not necessarily with all the other things that people found fault with. But it was ultimately upheld, at least in part. The second thing is, I think that the Commerce Clause issue was unprecedented in the sense that if you view what the mandate was about, if you think of it as a compulsion to engage in activity that an individual had not engaged in before and was not intending to engage in, then it is unprecedented in that regard. On the other hand, if you view this as economic regulation in which this government is stepping in to decide when you will pay for your insurance and to be sure that you have the insurance, then it seems to me perfectly consistent with what we have done before in other areas of regulation. Now, I don't think there's a right answer to that question. I think it depends on the lens with which you view it. The Rehnquist Court would have viewed it as the 5 votes did here, and the one thing we do know is there are 5 votes for a narrowing construction of the Commerce Clause. What we don't know is how far they're going to do it. My own view is I would have voted the other way because I think it matters that, after all, we could have had Medicare for all, in which there would have been a tax on everybody. Everybody would have paid for it. It would have been more intrusive than this bill. Of course, the Congress wasn't going to vote for that. But if you're thinking about it from a constitutional perspective, it seems to me to matter. Second is, no state could possibly do this on its own. The spillovers between the states was too great, and there's no way this could be done. Seems to me those are worthy of consideration in trying to decide at what level of generality and through what lens you're going to view this. Now, let me say a couple of other things about this. Oh, on the necessary and proper clause, I completely agree with the majority. The necessary and proper clause does not say that Congress has the authority to do anything they consider necessary and proper. It says to carry out the foregoing powers. And that means you have to be able to point to something in the Constitution. In this case, it was the Commerce Clause or the Tax Clause or something else. And I agree with that. The court, beginning with McCulloch against Maryland, has been very squishy on looking to these, whatever else it is that they're relying on. There was a case a couple of years ago involving the federal prisons and whether they could keep people in afterwards that was relied on for necessary and proper. I had a lot of difficulty explaining to my students what clause of the Constitution was the linchpin for the necessary and proper for the next stage. So I completely agreed with that. Now, let me just make 1 or 2 other points, and that is I want to talk about broccoli. Now, I want to be on record saying I do not eat broccoli. My children and my grandchildren know that I hate broccoli, and I will not eat it under any circumstances. And I think it would be really wrong to enforce me to eat broccoli or even to buy broccoli. But the question is it any less wrong if the state of New York, if I live there, required me to eat broccoli, or the federal government didn't make me eat broccoli. Now, it's true that it would affect more people, but if the issue is individual liberty, then it's a due process issue. It's not a Commerce Clause issue. And so I never felt that I could swallow the broccoli argument, hook, line, and sinker, because it just didn't seem to me to be the right response. There may be an area beyond the federal government's reach, and I've said so. I think that the prior cases, the guns case, guns of the school, and Morrison, the violence against women case, not me, were right. That the Commerce Clause was not intended to do those things. There are lines. The court had made it clear before. Randy Barnett and I, which may surprise you, were co-counsel on the Raich case. And I thought that the federal government had gone too far in regulating the simple possession of marijuana. The court said, no, not a problem. Justice Scalia said necessary and proper to do all of these other things, which, of course, the Congress had never said they were going to do. So I have a couple other things. I'll talk about the tax issue a little bit later, but I think I'll stop for now.
So let me draw Mike Carvin into the conversation, and I have a particular question, but I'm sure there are things you want to respond to also, Mike. What I'm interested in is, so we've heard a lot about what happened. I wonder if any of these doctrinal developments have teeth, whether as a consequence of what the court did in the case, Congress will have to act differently, or whether this is a kind of abstract discussion only.
Yeah, I'm probably less sanguine than Randy about the future constraining effects of this decision. I think there's some good rhetoric on the Commerce Clause. I think there's some good rhetoric on necessary and proper. And surely it's very valuable for the court to have said that under no conception of the Commerce Clause can you compel a person to buy a product. The problem is what they just gave you with the left hand, they take away with the right. You can compel anybody to buy any product you want. Justice Roberts will call it a tax, and you'll come out with exactly the same result. And there's no language, there's no English language that you could use to more directly convey that the individual mandate was a mandate than the language they chose in the Affordable Care Act, and yet you had 5 justices saying, no, that was really just a voluntary option and a tax. And since we seem to be well established in the view that the Congress can tax any activity, then it seems to me they can go to the taxing power. Even if they didn't invoke it, even if they call it a non-tax, they can have 535 people swear up and down, though this is a penalty for unlawful activity. None of it matters because the court can turn it into a tax. So even in terms of the narrow direct effect of the Commerce Clause ruling, invalidation of compelled purchases, I'm not sure that that's going to have any sticking power. I think the Medicaid issue is not one I got involved with. That was conducted by Erin and Paul on behalf of the states. It really didn't affect us. To show you my gifts of prophecy, if you want to discount everything I just said, going to the argument, I said, look, I know 2 things aren't going to happen. Nobody's going to buy this tax argument. Nobody's going to buy this Medicaid spending argument. So I was 2 for 2 on that. And
predictions are very hard, especially about the future.
And the good news, by the way, on the Medicaid spending, I don't know what it'll do for the country. We've now established a standard analogous to, like, how big is a punitive damages award under the Due Process Clause,
Yeah.
which will keep lawyers busy for the next 15 years, picking out statutes at random and saying, gee, this seems sort of coercive. And so it's a gift to the bar. Whether or not whether states can comply with it or want to comply with it, I'll leave that to Erin to comment on.
So you all probably remember it was a 3-day argument. It was a marathon argument. And the first day was the day that many people, certainly my editors, cared least about. They didn't even put my story on the front page. They put Randy on the front page instead. And that was the day when the court considered whether it had the power to decide the case under the Anti-Injunction Act. And it turns out, and Josh's book is particularly good on this, that there were the seeds of what would happen on the merits on the tax question in that first day's argument. And I thought I'd ask Josh to sketch out a little bit about what went on there, and then I'm going to ask Alan, who had a role in framing those arguments, for a more normative assessment.
Okay, sure. So I'm going to bore you. Tax law. There's something called the Anti-Injunction Act, and what this law says is if you don't like a tax, you have to pay it first and then sue later. The reason why we have this is because we have a very bad idea to allow people to sue whenever they don't want to pay a tax. So you pay the tax, you can sue for a refund. This law has been in effect for over a century. Initially, when the government first argued this case, they said, well, this law is a tax, and because it's a tax, you can't challenge it until 2014 when it goes into effect. But there was a big problem with it. The statute clearly said it was not a tax. They might disagree, but the statute was framed in terms of penalty. In fact, to read the legislative history, they said maybe it was a tax, maybe it was not. But courts rejected this. They said, listen, it's not a tax. It doesn't say it's a tax. And this case was, this argument was unanimously rejected. So the government actually dropped the tax argument. But going up to the Supreme Court, the Solicitor General had a very interesting realization. Even though the lower courts had consistently rejected the argument that it was a tax, he read a case which you might have studied in common law called New York vs. United States. It was a Justice O'Connor opinion about federalism, 10th Amendment stuff. But there was one part of the opinion that was very significant. And the opinion said, basically, if Congress passes a penalty that would be unconstitutional, and if it could be construed as a tax, we should uphold it. And this case was cited for that very proposition. And what happened was the government made this argument not on the second day, but on the first day. When everyone was talking about Anti-Injunction Act, whatever, the government was saying, we need to say to the Chief Justice, and Solicitor General Verrilli said this very clearly, if you can construe this as a tax, you have an obligation to do so. He said it over and over again. He called it the reasonable way of reading the statute. And no one was paying attention. I didn't even pay attention. But the Chief Justice asked, I'm sorry he's not here, Michael's partner, Greg Katsas, the Chief Justice asked, Counselor, if we could construe this as a tax, that is, that there's no other collateral consequences for failing to have insurance, why shouldn't we? And they knew that question was coming. And I was told by one of the lawyers for the challengers, if the Chief Justice made that inferential leap, he's home free to uphold the law. And even though all the attention was on Commerce Clause and limiting principles, I think there the SG didn't do a very good job. He kind of took some gambles that didn't pay off. On this case, he made the argument that actually was accepted. And the essence of the Chief Justice's saving construction was right in the SG's brief. And now I'm welcoming a talk by Alan Morrison, who authored an amicus brief on behalf of two former commissioners of the IRS. And they argued that this argument was not at all good and that the Anti-Injunction Act should not have been waived. Alan?
Sure. When the first case was filed by Attorney General Cuccinelli, I was completely outraged that a state attorney general would think he had standing to go to federal court and enjoin the operation of the tax code. First place, he had no standing. Second, case wasn't ripe. And third, there was the Tax-Injunction Act, which I knew about. This had been a very strong tool in the government's arsenal in many, many situations, and the court had given great deference to the government's interpretation of the statute and has applied it to many things that were also labeled as penalties as well. And it seemed to me, both for three separate reasons, that this was a good argument to make. First is, in my experience litigating cases, the longer a law is in effect, the less likely it is for the court to strike it down. And if people are starting to get benefits from this law, it's harder to get it struck down than if it's in its nascent stage and people are just hoping to get benefits. People don't realize what's happening. So that was argument number one. Argument number two was it showed that that when we argued about this issue, it underscored that this was really about the tax code. And in order to understand why the Tax-Injunction Act didn't apply, if it didn't apply, you had to understand what this law actually did and how it operated, and how it was very much like many other provisions in the tax code that provide for penalties when a person fails to do something, whether it's gasoline at EPA or importing some goods or any number of things, gambling taxes. All of these things are similar to what was going on here. Those are penalties under the code. And so the second part of it was to get them to focus on the issue of that this was really a tax. And the last part was I thought that this case always had a better chance of winning as a tax than it did as a Commerce Clause argument, and that the government was unwise to abandoned the Tax Injunction Act because it made it very awkward. So on the first day of the argument, Justice Alito said to the Solicitor General, Mr. Solicitor General, I see that tomorrow you're going to be arguing that the amount payable is a tax, but today you're arguing that's a penalty. Do you think there's some inconsistency in that argument? And he sort of went like this, and he said, no, I don't. And of course, Alito was completely unconvinced. And indeed, in Justice Scalia's opinion about the tax issue on the merits, he said this proves that it can't be a penalty one day and a tax the other day. So part of the argument was to first to get them to focus on the real tax aspect and why this looked like a tax, operated like a tax. It was reportable on your income tax. It was subject, the amount you had to pay was based on your income. And the effort was both to get them to not decide the case, because I thought it would be more likely to affirm it later on, but second, to get them to focus on the tax aspect so that if they did get to the merits, they would be more likely to affirm it. So, like Randy, who takes credit for much of the else, I take credit for Justice Roberts' understanding that this was in fact a tax, although I have no illusions that that's why he actually decided it that way.
Erin, you clerked for the chief, and you were at the arguments on sort of the main day, the middle day, the second day. Almost no discussion of tax, but on the first day, as Josh has described, there were the seeds of what was going to happen. Were you alert to that? Did that ring any bells at the time?
It certainly did not go unnoticed by the challengers. I think everybody is very in tune to everything that was going on in this case, and it was very obvious that that was an important question and something. I mean, you will note that the next day when the tax power was discussed, it was actually discussed by the challengers. So, this isn't some issue that kind of came out of absolutely nowhere for us, and it was something we caught on to there. And I think that the argument was right there in the briefs and was always the kind of thing that there's seeds in the court's past jurisprudence that would suggest it's the kind of thing the Chief Justice would find appealing. This isn't the first time that he's, come up with gone for a statutory construction that's not obvious on the face of a statute to avoid a difficult constitutional question. So, I think this is something everybody was in tune to. It's also something that at the end of the day, there's not a whole lot you can say to the court when it comes to the question of do we want to reconstrue a statute to say something it doesn't really say. There's not a great argument in response to that, so it's just kind of something that you make the best argument for why the statute doesn't say that, and hope that that they're with you enough on the constitutional questions and everything that they won't feel the need to construe a statute that way. But it's one of these things that at the end of the day, if the court's going to do it, the court's going to do it. So.
Randy, if granted re-argument, what would you say on that point?
On the saving construction?
Yes.
Well, it's a very dangerous power, actually. I think what I would say is that this is a judicially aggrandizing power. It aggrandizes the judiciary at the expense of the Congress and the people, because what happened is John Roberts, because he's the only one who did this, by the way. We can talk about 5 justices, but this was his maneuver. 4 justices were perfectly happy to accept the mainstream law professor argument that Paul finds so convincing that Congress has a plenary power to regulate the national economy, and all means that are necessary to do that they can do, unless it violates an express prohibition in the Constitution. That's what 4 justices thought. 4 justices thought this was unconstitutional and the law should be struck down. One and only one justice thought that the only way to uphold this law was to only one justice thought the law was unconstitutional as drafted, because it exceeded both the Commerce Clause and the Necessary and Proper Clause, but that the court could give it a saving construction which changed the individual responsibility requirement enforced by a penalty into an option to buy insurance or pay a small non-punitive tax. That was something that's open to the court to do. Only one justice thought that was an appropriate way to go and the only way to go. And I think that's a very dangerous power. Because what it means is, as Erin just suggested, when you go into court, all you can do is challenge the law that was written. And what ended up happening is John Roberts wrote another law that was never enacted. We don't know if there were the votes to pass that law or not. In fact, there's some reason to think there wouldn't be the votes to pass a tax law, because that's the reason why they didn't call it a tax in the first place, because there's political salience to calling something a tax. And if Mike is right, that from now on, no matter what Congress does, the court is free to rewrite it in a way that it makes it constitutional, no matter how unnatural that reading is. That's a very dangerous power to put in the hands of the courts. And so that's what I would say on re-argument.
If I could just tack a quick addendum to that answer. I mean, I do think one thing not to be overlooked here is the way the Chief Justice did this required him to decide a very important constitutional question about the direct tax power that received about 2 paragraphs of briefing in the case as a whole. So certainly if I had the argument, the opportunity to rebrief, that would be a constitutional question that I think would warrant a good deal of discussion before being decided.
Isn't there a related question of whether it makes sense for the Chief Justice, having decided that he could read the statute as not being a mandate at all, to have a whole section of his opinion first deciding whether a mandate, if it was there, would be constitutional under the Commerce Clause? I mean, it seems like it was kind of an aggressive thing for a justice to say, I'm going to uphold this because I'm not going to read it as a mandate, but I'm going to tell you if it were a mandate, it would violate the Commerce Clause.
Look, a justice, from the way I understand holding in dicta, a justice or a person writing an opinion is entitled to adopt his own reasoning. And that's the reasoning that is the holding of the case, if there is a holding there. And on his reasoning, it was because of the constitutional infirmity with the most natural reading of the statute. It was because the most natural reading of the statute would exceed the Congress's power under the Commerce Necessary and Proper Clause that he then was justified in adopting a saving construction that was not the natural reading of the statute. That was his logic. He gets to control his logic, even if there was an alternate route that another justice, call that Justice Ginsburg, for example, could have taken to reach the same result. That doesn't make the alternate route the holding of the case. The holding of the case is the reasoning that of the justice, in this case the 5th controlling justice, that decided the case.
The usual approach in constitutional avoidance kind of situations like this is to avoid deciding the constitutional question if you can avoid it by construing the statute to make it constitutional. You don't usually decide that construction A is unconstitutional and then go ahead and rule on construction B. That's just not the way it's done.
Well, Paul, there's no question, I think, that what Justice Roberts did here in the way he adopted a saving construction was, if it wasn't entirely novel, it was creative, to say the least.
Well, I agree with you on that.
Well,
Which is one of the reasons why it actually... which is one of the reasons why it was part of the bad ruling in the case. So there's 2 bad propositions of law that this case stands for, which Mike has already highlighted. The first is this saving construction maneuver, which is a relatively novel and new and dangerous power which the court should not be engaged in. And the second is the tax on inactivity maneuver, which also hasn't been done in the history of the country without dealing with the direct or indirect tax route. And the only thing I want to say about that in response to Mike's earlier point, and very pessimistic point, is that it was still a modest victory to hold Congress to simply taxing inactivity rather than allowing this to be punished as a Commerce Clause violation. And to illustrate the difference that this makes in practice is imagine that the Controlled Substances Act were enforced under the courts, under John Roberts' tax power theory. That would mean that punishing people by sending them to the penitentiary for violating the drug laws would be unconstitutional. And and we would have to open up the doors of the penitentiary system and let everybody out who had used a recreational substance, provided that they paid a reasonable, non-punitive tax on that activity. And everybody in this room would be perfectly legal in using these substances, and you could declare so on your bar application if you wish to, because you would not be violating the law if you use these drugs. That would not be a perfectly libertarian...
What about all the people who are in jail for gambling?
Pardon me?
The gambling, all the gambling laws in this country are basically tax laws, and people go to jail all the time, or they used to go to jail all the time for it. We've gotten smart enough so we don't do that anymore. We have state lotteries instead. But surely that's not unconstitutional because it's the tax power.
You misunderstand me, Alan. I'm not saying it's constitutional or unconstitutional.
Well, you said
what I'm saying is that the power that the court recognized is a less dangerous and onerous power. I'm responding to Mike. I'm not responding to you at this point.
Okay.
The power is a less dangerous and onerous point than if the very same law is being enforced as a Commerce Clause regulation, because a lot more serious things can happen to you if you violate a Commerce Clause regulation than if you violate this new tax power theory that the court has invented.
That's true.
But if we have a tax, they chose not to put a criminal provision in this. They chose not to include some of the normal means by which the tax was collected so that it would be less coercive. But surely, if Congress had chose to suppose somebody files a false tax return in this situation, says they have insurance when they don't have insurance, surely they could prosecute you for that. And surely Congress could change its mind at some time in the future. It hasn't done so. But I don't know that this is such a clear line between them. I agree.
But much of the Chief's reasoning did turn on what he saw as the modesty of the penalty. Mike, were you going to say something?
He observed it. How much it turns on, we'll see in maybe some other case, although I doubt that there are going to be any more like this one for a while.
That seems right.
This forum is probably a good reflection of the opinion because I've completely lost the thread of argument. But so I'll make a few unassailable propositions.
As you always.
That's when we start to worry. I got to get my pen out.
The Chief Justice's statutory interpretation was nonsense on stilts. I mean, it just was utterly absurd. And I'll use Alan's example, right? I mean, everybody understands that if you prohibit gambling and enforce it through a $50 per event penalty, then that is not a tax. Whereas if you say, if you want to engage in gambling in Las Vegas, we'll take a slice out of our tax revenues, or if you ban cigarettes and have penalties. So, and the one thing that had been consistent in the court's jurisprudence, that the absolute acid test of what separated a penalty from a tax was the fact that they made the underlying activity unlawful, as they did in this act, by saying you have a requirement. If you don't meet the requirement, you shall buy insurance, you will pay a penalty. As I say, you can't choose words from the English language to more clearly convey that you have committed an unlawful act if you don't purchase insurance. So there's no argument by any standard that this was a tax or could properly be construed as a tax, in addition to the fact that it, of course, completely reversed what they had said on Monday about the Anti-Injunction Act. Do we care about rewriting statutes to avoid constitutional questions? You know, sure, great. He did it in the Voting Rights Act case, as you know. And like, fine, you don't want to get to the issue, don't get to the issue. But that's not what happened here. He rewrote the statute in a way that gave Congress this new taxing power, which, outside the criminal context, is the functional equivalent of what he correctly characterized as this potentially tyrannical Commerce Clause power. So he didn't in any way limit Congress's power that had so bothered him in the Commerce Clause context. And third, he didn't avoid a constitutional question. He went on and in two very blithe paragraphs decided this direct tax question, which they had devoted, 20 lines in their brief to discussing. So he didn't avoid a constitutional question. He just got to another constitutional question, and to cap it off, decided that wrongly as well. So that's my one man's view of what happened in court.
So in exploring this question of does this case have consequences? Does it have teeth? I was trying to review in my mind, will there be briefs this term that cite it? And I haven't read it, but I'm suspecting the Bond case does cite the NFIB case, and perhaps even has a saving construction argument in it.
That you are right on both counts. We filed a brief this morning that cites NFIB at least once.
So say a little bit about that case, because the facts alone are so delicious.
Sure.
The legal stuff, not so much.
Erin, who do you represent? Do you represent Bond?
We do represent
The
Bond.
poison.
Yes.
Good.
Oh, that's right.
It is Bond versus United States. So this case is actually back at the court for the second time. It's a very interesting underlying factual case and a very interesting legal issue. Our client is a woman who discovered that her best friend had been having an affair with her husband and was pregnant with his child. And she basically at that point kind of had a mental breakdown, and she worked at a chemical company and obtained some chemicals from her employer, and also just some that you could get over the internet, and started spreading them on like the handles of the car that of her former friend's car, and doorknobs to her home, and various places like that. These chemicals were apparently bright orange, so the woman saw them all the time. She didn't actually suffer any serious injury from any of that. I mean, not to minimize that, I'm sure it's a very terrifying thing to have somebody spreading chemicals all over surfaces around your house. But where this becomes interesting is the federal government decided to come in and prosecute this as a violation of the act that implements the Chemical Weapons Convention, prosecuting her as having used chemical weapons against this person. You know, it's like kind of basically neighbor. You know, all of this feels like a pretty local domestic dispute, basically. And our client spent, I believe, 5 years in federal prison. The case first made it to the court because the government initially argued that she didn't even have standing to challenge her conviction when she argued in court that this was an unconstitutional, that it exceeded Congress's power. 190 on that. The United States actually ended up confessing error and saying, no, now she does have standing, and the court agreed unanimously. And so we are now back up on the actual merits question, which is also itself an interesting one. The government's primary theory in the case is, or its original theory in the case was, Congress, well, first, the federal government can enact treaties on basically anything it wants to, and there's really very little, if any, kind of judicial review on that. And once a treaty exists, Congress can enact any kind of legislation to implement the treaty, and there is essentially no judicial review on that either. So if you have a treaty and you have a law that you can come up with some means by which it is rationally related to the treaty, then Congress can do all sorts of wonderful things that it could not do under various other, you know, if you were just looking at its Article I powers alone. So that's the main question in the case. It then also is interesting that the government, changing positions a few times in the case, has also now decided that it wants to defend this legislation as Commerce Clause legislation. So we've got the Commerce Clause back before the court in this case. And then just to kind of give you a little more redux to all of it, we have made an argument as challengers that, you know, it might not surprise you that there is a way to read this statute as not treating her conduct like use of chemical weapons. So we also have presented a statutory construction argument to try to allow the court to get away from these difficult constitutional questions and adopting a theory of the treaty power that would have absolutely no limits itself. I do think there are a lot of ways in which the NFIB case is really interesting here, and one of them is really the theory of the treaty enacting, the kind of treaty, there's, you know, the treaty making power and the treaty implementing power, and on the implementing side, where the government's trying to derive the power is from the necessary and proper clause. And so, you know, part of their theory is that there aren't really limits there beyond rational relationship, and perhaps not exactly clear, but maybe, you know, if the legislation violated something like the anti-commandeering principle from New York or Prince, although I'm not totally sure the government even concedes that. But so, you know, there's really an argument in the case here again about the point at which the legislation can really be improper because it is just inconsistent with the federal structure of our government and the notion that there are rights reserved to states and that the federal government can't exercise a police power, whatever else it can do. The court has always said it can't exercise a police power. And so, you know, that's kind of been our core argument in the case. And I think, you know, NFIB, it's not like you're going to read the briefs in this case and that's all anybody's talking about. I mean, you will note that the government's brief does not cite it at all. You will note that our briefs cite it a few times. And you know, I think the arguments will be very much, I think, in the court's mind when they hear argument on the case in November.
Erin, if I add one point to that, I think one of the takeaways from NFIB, to go back to Alan's point about due process, the court's been very clear, particularly through Justice Kennedy, that the structural protections of our Constitution are just as important to protect liberty. In Justice Kennedy's joint dissent, he said very clearly, structure means liberty. He said it twice, structure means liberty. And I think you've seen this same trend in a number of cases from the Voting Rights Act, where they talk about the dignity of the state to protect the people, to Windsor, the DOMA case, and Randy Barnett blogged about this, the issue that the states exist to protect the dignity of the people. The notion that the states exist to have this protection into liberty pervades everything. I actually have a post on Volk. If you load it up right now, you can read it. But I think that's one of the bigger takeaways from NFIB. It's not just that due process is a way to protect people, it's the structural protections of our Constitution which can protect people. And we'll see this in the Bond case, we saw it in the Windsor case, we saw it in the Voting Rights Act case. And you might agree or disagree with that, but there seems to be 5 votes in the court one way or the other for that proposition.
Erin, can I ask a question? Are you arguing that the government didn't have the power to enter into this treaty, or that it didn't have the power to enact the legislation? Because I think those are two rather different questions.
Absolutely. We are arguing the latter.
Good.
We have conceded the validity of the treaty, and our question presented is whether the enactment of a valid non-self-executing treaty renders any effort to implement it automatically constitutional.
Right.
The government's brief spends probably almost half of its time talking about the power to make treaties.
Yeah, yeah.
So, both issues are in the case.
I take it that we could carry out our treaty obligations by inducing the states to pass laws on this as well.
Well, I mean, in this case, the states already have laws on all of this.
Murder is
so,
against.
You don't need anything.
Anybody from Pennsylvania? Murder is against the law in Pennsylvania. I think, yeah, attempted murder.
She easily could have been prosecuted under any number of state statutes.
Erin, I think it would be also useful to say what the saving construction is, because I think it gives an example of how saving constructions can actually be used to reasonably interpret a statute so that it doesn't lead to the nonsensical result of 7 years in the federal penitentiary for burning the thumb of your neighbor with a chemical you bought on Amazon.com because you violated the chemical weapons ban. So tell us what the saving construction is, because it's very interesting.
Sure, yeah. So the statute presumptively makes any toxic chemical, any chemical that could harm any person or animal, a chemical weapon. And then it contains this separate set of provisions that says, except when you possess it for these purposes, and one of which is peaceful purposes. And then for peaceful purposes, it gives these explanations of kind of like industrial, agricultural type purposes. But,
and other.
And other. And peaceful purposes is actually, what our argument is, and I think there's plenty of support for this. The government actually doesn't really quite dispute this point. I mean, it's basically an international law term of art that is used when talking about nation states to determine whether their conduct is warlike or non-warlike. And, it might necessarily need to be peaceful in the kind of sense that we think about that term colloquially, but for purposes of a government, it matters if what the actions you've taken would kind of constitute acts of war for international law purposes. So what we've said is peaceful purposes, which was taken right out of the convention and is now applied to individuals, should have the same basic meaning. And you can actually put meaning, I know it sounds a little abstract to think about what is warlike when it's done by an individual, but there's a pretty good place to look for this. There's terrorism statutes, and one of them is a statute that actually contains a definition of terrorism, and it defines it as individual conduct when it's motivated toward harming a government property or official, or when it's taken to try and influence the activities of government. So there's content in the law to show how you could take this term that has this meaning in international law and understand how Congress has told you to interpret that as applied to individuals, and assume that Congress really intended for this statute to reach things like acts of terrorism rather than domestic disputes that involve chemicals. And just to kind of cap it all off, this statute is a predicate for some of the terrorism statutes in the U.S. Code. So if you have committed the crime that our client committed, you would be treated as having committed an act of terrorism, and if somebody helped you, they would have harbored a terrorist, which all suggests maybe this isn't exactly what Congress envisioned the statute covering when it enacted it.
So I want to turn to your questions in just a minute. Let me open, and maybe you can gather your thoughts. Let me open just one last set of questions, which is, I feel like I heard Paul Clement on an occasion like this before the case was argued, say offhandedly, hey, it's a 2,000-page statute. Some part of it has to be unconstitutional. What other parts of the statute might still be subject to attack? Mike?
3 off the top of my head, 2 of which I'm already bringing. One has nothing to do with the Constitution, but this very carefully drafted, well-read statute says you can have subsidies for people who go on the health exchanges, and that's what triggers the employer penalty for not insuring them if the state is running the exchange. But it makes no such provision if the federal government is running the exchange. In reality, 34 of the 50 states are run by the federal government, so there won't be subsidies or employer penalties under the plain language of the statute in 34 of those states. The other one that I'm sure you've heard about is the contraception mandate, which basically forces through regulations people to violate their principles of religious liberty and conscience and provide money, actually famously at this law school, I guess. When I went to law school, I didn't expect the law school to subsidize my contraceptives. I sure didn't expect to come to a school and say you've got to violate your religious principles in order to buy me contraceptives. And we think under basic principles of religious liberty, most obviously in the Religious Freedom from Restoration Act, that regulation is unconstitutional.
Where are those cases now, Michael?
Unfortunately, there's 11 of them, so to give you a brief summary would take us through midnight. The gist of it is, after a lot of backing and forthing with the Catholic Church and others, HHS finally did memorialize its so-called compromise position in a regulation about 6 weeks ago, and a lot of the cases have been refiled and started all over again, because one of the arguments the government was making was you can't challenge our decision until we've made a decision, and now they've made a decision. The final one, sort of interesting, is there's some compelled speech provisions in the Act which require employers to do various things which are, in my view, vulnerable to constitutional challenge.
Any thoughts on these follow-on challenges? I have just one, which is this contraception mandate is like a perfect newspaper storm, because the basic question is sort of like Citizens United. Citizens United said corporations have First Amendment free speech rights. Here the question is, do for-profit secular corporations have free exercise rights? Citizens United plus Obamacare, poof, front page.
It's going to be, it's interesting, the issue is very closely related to what you're seeing in the area of responding to the advances of gay rights, which is the continued assertion of the freedom of religion right to continue to discriminate against people. And I think in the end of the day, the answer has to be that a business can be regulated in ways that individuals can't be. That's going to be the end of the day what the line is, I would think. Now, maybe not. But
to be clear, our clients are the Catholic Church, Catholic Conference of Bishops. They're not for-profit corporations. And no, I don't.
There are some corporations that are bringing this claim, right?
Yeah, and I don't see why they lose their First Amendment religion rights any more than they lose their First Amendment speech rights, because they've been characterized by the IRS in a particular way. But I do want to make the point that, no, you really can't say that you can tell the Catholic Church not to discriminate against women priests because of our growing values of equality.
Totally agree with that.
Okay. So then we really do think there are certain autonomous actions, certain spheres of religious liberty that are beyond the control of the federal government.
Absolutely.
What is the Catholic, how is the Catholic Church a plaintiff? That is, what are they required to do?
Insurance. There's some self-insured entities, and then there's various law schools and the like that have to comply with them.
But they are, well, I guess I'm just curious as to the exact relationship between them and the church.
The Catholic Church has janitors for its churches. They have to pay them. I mean, there's all kinds of lay people that work for an entity known as the Catholic Church. It's not just priests and nuns. Okay.
So this has been a fantastically rich discussion. We touched on a lot of things, and I'm eager to have your thoughts about following up on things we have touched on, or perhaps pointing us toward things we ought to be thinking about. Any questions out there? Yes. Why don't approach the microphone, and please keep your question in the form of a question.
Sure, all right. All right. I am wondering about that. I had another question, but I won't ask it. I'm wondering specifically about what you just talked about. The difference between regulating an individual and regulating a corporation. Specifically, actually, the reference you made, where we regulate that certain corporations can't discriminate against certain people. I was wondering if you could flush that out, because we don't, and I don't think we could be able to regulate that people can't discriminate. People can, but we say that corporations can't in certain contexts. And I was wondering if you could flush that out, why we can regulate the one and not the other as a free speech issue, ignoring the obvious. I mean, you don't have to ignore anything but the Commerce Clause aspect.
I mean, I can give you the political science answer, right? Which is the general argument for telling people who they can hire and how they can regulate their employees is that these are morally irrelevant characteristics. That was, of course, what Martin Luther King so famously said 50 years ago. He wants them to be judged by the content of the character, not the color of their skin. It seems to me a much more debatable proposition that you can tell people in a pluralistic society where we purportedly value diversity that we're imposing a set moral code on them when it comes to things like paying for other people's abortions or contraceptives. Now, I don't care at all about contraceptives. I'm a huge supporter of contraceptives, but but unlike my colleagues to my left and right, I don't think that my personal code should be imposed on America in the guise of federal law. I think we should allow people to pursue heterogeneous, diverse viewpoints when it comes to issues of bedrock religious faith. That's my political science answer. So I can distinguish all of the freedom to discriminate on the basis of race is not a freedom that anyone cares about, because no rational person would ever discriminate on the basis of race. The ability to make distinctions on fundamental issues like abortion and things like that, I seem to me, are at the heart of a pluralistic society where you don't want to stamp out one viewpoint.
Thank you.
You think it would be unconstitutional if the federal government taxes paid for abortions before, as they did before the Hyde Amendment?
You know, you really got to get into this whole. You mean we're talking about a dedicated tax? You're going to tax every, or
I
just
can do it
general
any number of different ways. I'm just trying to figure out what your position is.
I think there's all kinds of things that the federal government spends my tax dollars on that I don't much like.
Yeah.
I think
like
think,
war.
No, actually, well.
You don't like war. You have defense of your clients.
Maybe half the time, but I do think there is something to be said for Madison's notion that when it comes to issues of conscience, taking somebody, and Jefferson made a similar point, taking somebody's money to support a church, for example, even though the government's got all kinds of broad authority, there you really are trenching on one taxpayer's freedom of conscience much more than allowing them to do the kinds of things that the federal government was empowered to do. Of course, all of this is an ahistorical debate, because if the federal government was doing the kinds of things it was actually empowered to do, we wouldn't be debating things like paying money for abortion in the first place.
Other questions? Yes.
I actually just wanted to piggyback a bit on the most recent answer by Mr. Carvin. You had said about issues of fundamental conscience being funded, and there's got to be a line somewhere. So how does that apply to more general provisions like school vouchers, a lot of which go to religious schools? And maybe people of different religions are like, all right, they go to different religious schools, fine, but there's hardly any such thing as an atheist school the same way as there is a Catholic school. And how does that apply to someone who maybe doesn't even just not believe in religion, but who believes religion is toxic, and et cetera, et cetera, et cetera?
I agree with Paul on this. I don't think the government should discriminate on the basis of religion. There's all kinds of non-denominational schools that have nothing to do with religion that get voucher dollars all the time. I don't think you should make religiously affiliated schools second-class citizens that must be discriminatorily denied those tax dollars, particularly when they've proven very effective in inculcating their often disadvantaged minority students with the kind of values and skills they need to succeed in American society.
Yes, please.
Maybe I can talk loud enough.
Try it.
I'm from Canada, where I greatly enjoy universal health care. And so my question for the panel, and I think it was touched on earlier, was, do you think it would in fact be constitutionally easier if the federal government had simply agreed to pay for the public health care?
Oh, that's essentially
I think
conceded, isn't it? Even Randy's written.
Everyone heard the question, yes?
Medicare for all, right?
Yeah.
Yeah, the answer is slam dunk, and much more intrusive, much more broccoli, and nobody would have the slightest doubt about the constitutionality. The reason that everybody said you can't pass because it wouldn't pass.
To 3 points. One, Justice Ginsburg asked this question in oral argument, and the constitutional question doesn't turn on whether it adheres more to the libertarian values of Randy Barnett or the statist values of Paul Smith. The question, the question is whether it adheres to the language of the Constitution. So that even though they do have a broad power to tax, instead they don't have any power to compel you to engage in commerce. And the notion that this would sort of would have been a slam dunk and easy and more intrusive is not true. They really don't affect you in any way. They don't compel you to Medicare. They don't compel you you to buy any products. It's a purely voluntary program. But the third point is
You don't have to pay. You have to pay your Medicare tax, right?
You don't have to take Medicare. Oh, you have to pay Medicare taxes. You don't
Okay.
have to
Well,
no.
you don't have to take the insurance here either.
Well, then you're just telling me that every tax is more intrusive than a compulsion to buy a product. Now, that can't remotely be true because I get taxed every time I buy a car, but the government can't require me to buy a car. But let me go to my third point, which is, if you do fund it out of the tax dollars, what does that mean? Everyone, at least not examine, most people pay tax. I didn't want to get back into the whole Romney debate, but that means that, and that's what we do, right? When we're asking people to engage in social welfare activities for the benefit of society as a whole, we're telling insurance companies or whomever, for example, that they've got to take people who are sick and pretend they're just as great an actuarial risk as people who are healthy, or tell hospitals to take sick people, we're asking them to sacrifice their own freedoms in order to benefit a societal good. And up until Obamacare, we'd always said, if you engage in those kinds of activities, we're going to pay you out of the public fisc. Since you're benefiting society, we're going to take money from society and reimburse you for the public good you've just done. But nobody wanted to do that in Obamacare. What they wanted to do was scapegoat a bunch of healthy 30-year-olds, call them free riders and freeloaders, and force them to pay above-cost insurance that they didn't need and would never need, and deny them the ability to buy the catastrophic insurance that might have made some sense for them actuarially, so they could single out and scapegoat this small segment of American society instead of honestly debating the costs and benefits of what you've got in Canada, which is a shared public responsibility, a shared restriction on freedom, and a shared tax burden.
Randy, Medicare, constitutional?
I just want to, before I answer that, I just want to say that the last argument that Michael made is the argument in the Jones Day brief. And that was an extremely important part of this case. It was the Jones Day argument developed by Jones Day, as Josh in the book makes clear. And it was the argument that appealed the most to Justice Alito of all the justices on the bench, and so it actually had a big impact in the case. Erin and Paul's brief really was more of a Justice Kennedy-esque type of change the fundamental relationship of the citizen to the state type brief, which really operated, I think, quite effectively on Justice Kennedy. And so both of these advocates are to be commended for the crucial role they played in the outcome here. With respect to the question, I said all along when we were building up to this case that if Medicare was constitutional, then Medicare for everyone would be constitutional, and that would be an easier case. However, I have to say that if a single-payer plan would be, the single-payer plan that would be constitutional would have to be the English system, I'm afraid, not the Canadian system. Because under the Canadian system, at least until there was a provincial ruling to the contrary, it was illegal for you to spend your own funds to provide for your own health care. And I believe that would have been in this country would have been a substantial due process clause problem. In the English system, you both have the National Health Service, but you also are able to spend your own funds to preserve your own life. And it does result in a two-tier type of medical service, which some people don't like on aesthetic or moral grounds. But I think on constitutional grounds, it would be the English system that would ultimately sustain constitutional challenge, not the Canadian system.
Let me just test your conditional construction for a second. If Medicare is constitutional, you say, is Medicare constitutional?
Well, under the established spending power doctrine, it's the Alexander Hamilton version of the spending power. Congress can spend the money that it taxes on pretty much anything it wants, and that would include this. So yes, I mean, under the Hamiltonian vision, under the Madisonian vision, which basically says that that Congress can only spend money. There is no spending power, actually. There's only a taxing power. That Congress can only spend money to pursue one of the enumerated objects that are otherwise listed on the list of enumerated powers. Then no, Medicare would not be constitutional. But that would really raise a much more fundamental issue about what the scope of the spending power is than I think this question was really asking about.
Social Security would be. So we're just about out of time, but let's maybe do two more. Right over here.
So I can't help but see a bootstrapping problem here. So free emergency rooms, therefore healthcare mandates. Ability to make treaties, therefore ability to aggrandize the power of the federal government to enforce them. Do we have to keep playing whack-a-mole with these different theories of aggrandizement, or is there a broader strategy that goes at the underlying problem?
Who's the we in your question?
Lawyers, broadly.
Well, I think that what we're speaking of is the EMTALA, the Emergency Treatment Something Act, I forget what it stands for. This is a law that says if you go to an emergency room, they have to treat you. This law was created because people were going to emergency rooms and hospitals were turning people away. So we had a problem, and government passed a solution to solve that problem, but that problem created another problem. That is the problem of free riding, people showing up at ERs and not paying. So you have a problem, government creates a solution to solve that problem, creates another problem. Then we need another solution, the individual mandate to solve that problem. So that bootstrapping question is interesting. There's a inevitable progress of problem, solution, which is something that government's been doing for centuries. But now the federal government in court can argue, based on these various necessary and proper arguments, well, we have this problem, we have to be able to solve it, even though it's a problem of the government's own making.
Erin, I'd be interested. What, is it Missouri v. Holland? What's that very...
Missouri v. Holland, yeah. It's the Byrd case. Yep.
Yeah.
Yeah, and I'm wondering, are you going after that? Or?
Oh, yeah. I mean, it's certainly...
Maybe you should give it back.
Sure. So Missouri versus Holland is a case from the 20s. It's Justice Holmes' opinion that has a line in it that essentially says if, the treaty is valid, then there's no question that the statute is necessary and proper. And it has kind of been assumed that that just means that's the end of it. There is no ability to challenge treaty implementing legislation. This is actually a holding that the court has never relied upon, so it's never actually been put back before the issue since then. And we certainly make a lot of arguments that you don't really need to read that sentence to say what it sounds like it says when you understand the context of the case and all of the other things that were going on. We also certainly make the argument that if you think that's the only way to read that sentence, then it is Missouri versus Holland is incompatible with the Constitution and should be overruled. So it's certainly central to the case, and it's another way in which this case is one of these ones that kind of, is about, did the court really mean some things it said when there were some really expansive versions of federal power going on, and does the court today, is it, willing to take those things at face value, or say, there's some real problems with these conceptions that the court had 80 to 100 years ago, and look for ways to limit that, or if it comes to overrule it.
Erin, in the Commerce Clause cases, the court always trots out the marriage and divorce. If we allow this, we'll allow the federal government to do marriage and divorce. Are you making that kind of argument in the treaty? If we entered an international treaty forbidding divorce, then the federal government could pass a law forbidding the states from allowing divorce.
There is a whole body of law review articles explaining how the laws enacted in Lopez and Morrison could be held constitutional because they are rationally related to existing treaties. I mean, this is, I don't think, a very difficult argument to make that there are treaties out there under which you could pretty much claim almost any law is rationally related. So certainly it's an argument we're making, and it's one that I think actually is really powerful in this particular.
Not only that, but this case is the slippery slope.
It is. Yeah.
Under this International Chemical Weapons Control Treaty, they are actually sending someone to the federal penitentiary because she burned the thumb of her neighbor who was having an affair with her husband. This is the law professor's hypothetical. It's already happened. You don't have to speculate about what might happen. This is that case.
What's the Commerce Clause argument, Erin? What are the government saying about the Commerce Clause?
They say that this statute is actually just regulating commerce in chemicals, just like race. You might ask, how is that so, since the statute doesn't actually, try to eradicate any of these common chemicals from commerce, which seem to be the linchpin of race. But nonetheless, the theory is kind of the general conception of, hey, these are articles of commerce and we can do things to regulate them, and if we didn't have restrictions on the misuse of chemicals, people might be a little less willing to sell chemicals, and it would undermine our foreign commercial trade interests, etc. I don't think it's the most
sort of backwards
powerful Commerce Clause argument, but we'll see what the court thinks. Did they just come to add another interesting element to it, the government explicitly waived the Commerce Clause in the district court, like openly said this is not a ground on which to uphold the treaty. But when the Solicitor General's office got involved during the first bond decision 3 years ago, they changed course on that. So,
does anyone have one last question? Right over there.
Maybe you can speak loudly too. Who said going into this that the political support and scholarly work fell behind the inactivity argument in a way that's unprecedented? If that had happened, if those factors had been there leading into race, do you think the state of the law would be any different today?
Sure, it's a wonderful question, and that is I'm going to repeat the question. So the question is, Josh was saying at the beginning that there was a popular we made an argument that appealed in the court of popular opinion, not just in the courts, and that is this compelled economic activity so that you may regulate it was something that that many people of the general public could understand, appreciate, and object to, and therefore there was a very public resonance against this law, which survives to this day. The law still is unpopular, and at the time the case was heard, a majority of people thought it was also unconstitutional. And the question is, if we had had a similar type of popular objection to the marijuana laws, the prohibition on medical marijuana in the Raich case, would that case have come out differently? I think the answer is likely yes, which I think really illustrates the importance of litigating big cases in the public domain. We actually did try as best we could to litigate this case in the public. That's one of the reasons why for at least 5 or 6 years I could not utter the phrase medical marijuana. It was always medical cannabis. Because it took me years to be able to say marijuana again, because as one of the lawyers in the case, cannabis sounded medical, cannabis and pharmaceutical, but marijuana, that sounds recreational, getting high. So it was always medical cannabis. It was never marijuana. We wanted to not make it a drug case, but unfortunately, I believe Justice Kennedy saw it as a drug case, and you got to remember he was the justice that was appointed when Doug Ginsburg's nomination went south on marijuana, when the Reagan administration was searching for a judge who was strong on the drug question as far as they were concerned. So that's Justice Kennedy. And Justice Scalia, I think, really saw this as another one of these foolish culture comp things out of the Ninth Circuit that he was not going to get buffaloed by. And they were not going to get this past him. And as a result, we lost both of these guys. And I don't know that we would get them back today. But I do think that one of the ways in which constitutional litigation works the other way is that I do think that by bringing the challenges that were brought in the Obamacare case, we actually delegitimated the law for a considerable period of time. Long after it was enacted and signed into law by the president, it was considered up in the air to the point where it could become the subject of first a congressional election and then a presidential election. So it had that effect. It gave the political process a chance to have another look at this law it otherwise wouldn't have had. And in the case of medical marijuana, I can tell you, when I started working on the medical marijuana cases in the late 90s, it was considered a really crackpot thing to be involved with. I should also tell you that I learned that do not rely on limo drivers that are part of the medical marijuana movement, because they tend not to show up on time. It was one of the things I learned in the course of being a lawyer in this case. So,
which I guess exemplifies the point that our experience with medical marijuana proves Justice O'Connor's view that this couldn't be abused in a way to be diverted to recreationally.
But I think what happened as a result, and I credit my client with this, Angel Raich herself, as a result of her efforts in the public domain for a period of 5 or 6 years, defending herself in public and going on all the talk shows and doing all this stuff, I think medical marijuana was legitimated in the minds of many more Americans than it was when we started. As a result of this case, it has been legalized in many more jurisdictions than there were when we tried the case. And so, in some respects, constitutional litigation can go the other way and can help vindicate or legitimate a movement that otherwise seems marginal.
Please join me in thanking this really terrific panel.
As always, thanks for doing this on.
My pleasure. This was fun.
No, Paul, you were better than you were.
What do you, how long are you hanging out with town?